It's Monday. Welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about mistrials. Cases that should have gone to the Supreme Court of Canada, but didn't. Mistrials in Canadian law are supposed to be granted in the clearest of cases. The question is whether Glenn Anderson met one of those clearest of cases. He was on trial for, in one case, manslaughter, and in another case, discharging a firearm in a negligent manner. Because of his status in the community, judges had to be brought in from an outside jurisdiction in order to hear his case. Two judges were brought in. One accepted a guilty plea for him on the manslaughter case, and the other judge heard a trial for him on the discharging a firearm case. In the course of the discharging a firearm, the judge called the parties into his chambers and asked Mr. Anderson, Crown Counsel, and Mr. Anderson's lawyers whether or not it would be appropriate, if Mr. Anderson was convicted, to sentence him together with the manslaughter charge. This revealed that the judge had heard about the other case that was being heard from the other judge who was outside the community. No evidence of his guilty plea in that case had been led in the trial for the firearms charge. And so Mr. Anderson thought that his trial became unfair and applied for a mistrial on the basis of judicial bias. He alleged that the judge, having learned of the manslaughter conviction, was now more predisposed to convicting him for the firearms offense, particularly given his question in relation to whether or not he should be sentenced together for them before a conviction was registered. This case raises an important issue of mistrial, particularly in circumstances where judges are brought in from outside jurisdictions. We now see this happening more and more as there's more access to social media, information is readily available at people's fingertips, and cases spread more readily throughout the communities. Judges need to be brought in from time to time in other jurisdictions in order to not be affected by the community that they live in and the connections that they have within that community. In this case, the judge had heard about information from another trial that could have affected the fairness of the trial. At least this was Mr. Anderson's point. And what happens in those circumstances? If there's a suggestion that there's some type of backroom talk about an individual who's before the court and their other cases, should not that individual have a new opportunity to have their charges heard by somebody who hasn't engaged in that backroom discussion? This is the classic example of when a mistrial should be granted, particularly given the steps that had to be followed prior to the trial even taking place. And yet the Supreme Court of Canada missed an opportunity here to clarify the application of the mistrial rule to these circumstances, which, in my view, amount to one of the clearest of cases. In these circumstances, there was the opportunity for the Supreme Court of Canada to get into an issue that it doesn't often get to talk about anyway, which is the law of mistrial, something that requires significant clarification overall due to the fact that mistrials are only granted in rare circumstances. The Supreme Court of Canada could have clarified the test for mistrial, particularly mistrial in the context of allegations of judicial bias, so that trials would be both more fair overall and perceived by the public as being more fair. By refusing leave to hear this case, the Supreme Court of Canada essentially left open a question of whether or not trial fairness was impacted by this, and left open the opportunity for public debate on the issue. That doesn't look good for the justice system, and it was an opportunity for the Supreme Court of Canada to prevent that from happening while making important statements about an unusual and often underused area of the law. You're watching Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Thank you for tuning into another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Please like, subscribe, share with your friends, and tune in next week for another exciting episode.